Well, hello everyone, and welcome to One Civil Law, where as always, we learn through the misfortunes of others. I am your host on Civil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're having a great day. Today, we're going to cover multiple motions to dismiss that were filed by Donald Trump in relation to the DC case currently against him in relation to the whole January 6th saga. So we've been covering this story, of course, and we saw on the 23rd, just 2 days ago, Donald Trump filed many motions to dismiss, and he made some pretty good arguments along the way. Not all of them I agree with, but some of them were quite good, and I thought we could cover them and see what he has to say. So as always, we'll try to evaluate this on the law and give you the best legal perspective that I know how to bring. So that's what we're going to do today. We're going to go over some of these motions to dismiss, at least in part, and try to go over some of the issues that we're talking about as it relates to Donald Trump. Fantastic. So we are, for today's purposes, in the United States District Court for the District of Columbia. As I'm sure you well know, Donald Trump is also facing charges in New York, Florida, and perhaps most critically, Georgia. We'll be covering that case a little bit more extensively probably tomorrow when an edited video is expected to drop. So this is just relating to the DC case from Jack Smith, the United States attorney there. So we will evaluate that case onto the merits. And President Trump filed 3 separate motions to dismiss on 3 different grounds. So I thought we could go ahead and cover that and see what we have to say. Okay, so President Donald Trump has filed this motion to dismiss the indictment, at least on this part, for constitutional grounds. Okie dokie. So let's see what those constitutional grounds are and see what it says. Donald Trump writes, the prosecution opens its indictment by stating that Donald Trump has a right, like every American, to speak publicly about the election. He sure does. Including his deeply held view that there had been fraud and other irregularities during the election and that he had won. These points are non-dispute. Nonetheless, in an astonishing display of doublethink, the prosecutor simultaneously claims that President Trump, simply by speaking his mind and petitioning for redress of grievances, and also incidentally, I personally like that, just to bring in the double hammer, because of course the First Amendment protects 5 separate rights. So not just the freedom of speech, which is a First Amendment right, but also separately the right to petition for redress of grievances, which is also a First Amendment right. And I like the fact that they didn't bury that lead. That makes me happy inside. So I bonus points there. Also somehow conspired to defraud the United States, oppress rights, and obstruct an official proceeding. Attempting to explain the obvious contradiction, the prosecution argues that there was no outcome-determined fraud in the election, whatever that means. Cute. And that President Trump supposedly knew this because some government officials had notified him that the claims were untrue. If there is any constant in our democratic system of governments, it's that the marketplace of ideas, not the mandates of government functionaries or its partisan prosecutors, determines the scope of public debate. Countless millions believe, as President Trump constantly has and currently does, that fraud and irregularities, that's the word I'm looking for, irregularities, thank you, pervaded the 2020 presidential election. As the indictment itself alleges, President Trump gave voice to these concerns and demanded the politicians in a position to restore integrity to our elections not just talk about the problem, but investigate and resolve it. I like the way this is written. This is very positively written. This is good. The First Amendment embraces and encourages exactly this kind of behavior, and therefore states in the clearest of terms that Congress shall make no law abridging the freedom of speech or the right of the people to assemble and to petition for redress of grievances. Yeah, so freedom of speech, freedom of religion, freedom to assemble, freedom to petition, and freedom of press are the 5 First Amendment rights. The indictment taken as true violates the core principle to each count. Accordingly, the court should dismiss the indictment entirely. Yeah, I mean, that's a pretty good line of argument, right? Separating speech in arguing about the speech as criminal is interesting, right? So you have speech here, and you're trying to say the speech is part and parcel of a criminal conduct, which can be true, right? Speech can be part and parcel of criminal conduct, right? If I say to you, let us go rob a bank together, and you say, yes, let us go rob a bank together, that speech is the formation of a conspiracy. So the mere saying of words can be sufficient. At least in conspiracy, we would then have to have an overt step in furtherance of the conspiracy. But the speech itself can be indicative of, or at least an element of, criminal conduct, right? So merely because it's word spoken doesn't necessarily mean it's immune. But by the same token, you don't want to sweep in speech that is just speech. So trying to figure out where that line is can get really, really tricky. And here, in this case, and also the Georgia case, I think to a large degree, you run into this problem where you have the idea of Trump exercising his First Amendment rights and freedom of speech versus him engaging in criminal conduct. And the line is not necessarily as clear, at least as it relates to Donald Trump. For some of the other people, it might be a little bit more muddied. But then again, some of those people did acts. They did things like creating lists or creating documents or other things that might themselves pose criminality. So Donald Trump didn't necessarily do those things. Where other people might have liability, Donald Trump doesn't necessarily have liability, because as always, we have to try to look at this unto each thing as to itself. So that's what we're going to. Okay. Additionally, the United States Senate has previously tried and acquitted the president for charges arising from the same course of conduct in the alleged indictment. The impeachment and double jeopardy clause both bar retrial before this court and require dismissal. I don't think so, but I appreciate their effort, but we'll get there when we get there. That part I'm not convinced about, but we'll give it a shot. Finally, because of our country's long-standing tradition of forceful political advocacy regarding perceived fraud and irregularities, I'm not sure why I'm having a problem with that word today, but we'll press on. In numerous presidential elections, the President Trump has lacked fair notice that his advocacy in this case could be criminalized, thus courts should dismiss under due process. That's going to be a little bit harder too. Basically, you're arguing that the law is vague, which is tricky at best, and I'm not sure it's true here, but we'll press one at a time. Okay. In ruling on a motion to dismiss for failure to state a defense, the district court is typically limited to reviewing the face of the indictment and more specifically language used to charge the crime. When considering a motion to dismiss, the court must review the face of the indictment, and the indictment must be viewed as a whole, and the allegations accepted as true. That is correct, right? Because on a motion to dismiss, you always take the complaint as true for the purposes of the motion to dismiss, right? That's how that works. You assume everything that the prosecution says or the plaintiff says, as the case may be, is true. The idea is that even if everything you say is true, we still win. So it doesn't matter, right? That's the whole point of the motion to dismiss. So yes, for the purpose of the motion to dismiss, you assume everything the prosecution says is true, because even if it's true, we win is the idea. President Trump fully denies the allegations, which are referenced therein. Moreover, the memorandum sets forth facts alleged in the indictment, so their legal sufficiency may be assessed for a motion to dismiss. Yeah, we deny the facts, but we will, like the court, assume them arguendo for the sake of argument, for the purpose of the motion to dismiss, which is how we normally do that. That's all fine. Great. Let's read some more. First and foremost, the indictment must be dismissed because it seeks to criminalize core political speech and advocacy that lies at the heart of the First Amendment. Okay. In United States versus Alvarez, the United States Supreme Court reaffirmed the broad scope of the First Amendment, holding it protects even verifiably false claims that a speaker had been awarded a Congressional Medal of Honor. They sure did. They sure did, yeah. So even false speech in and of itself is the thing that they were trying to criminalize, by the way, was naked false speech, right? So it wasn't claiming to be a Medal of Honor recipient. and in order to get a benefit or for the purpose of fraud or for other things, right? That is still very illegal. What they were trying to make illegal was just the simple naked claim. I have a Medal of Honor. And the Supreme Court said, no, the simple naked claim is not enough because the naked claim by itself is just speech. If you're using the speech to obtain some sort of benefit, to induce someone to do something for you, if you're using the speech to obtain something, procure something, defraud someone of something, then sure, that's fine. But the naked claim by itself is not enough. Okie dokie. Alvarez has produced his multiple opinions, but on one key point, all 9 justices were unanimous. Under the First Amendment, the government may not prohibit or criminalize speech on disputed social, political, and historical issues simply because the government determines that some views are true and others false. Our constitutional tradition stands against the idea that we need Oceania's Ministry of Truth. That's cute. I like that. The 4-justice plurality opinion, and oh my God, anytime we have to count votes makes my brain hurt. But let's try to press on about it, right? So trying to count to 5, right? It's like, okay. The 4-justice plurality opinion of Justice Kennedy was emphatic on this point, rejecting the notion the government may decree the speech about receiving medals to be a criminal offense, whether shouted from the rooftops or made in a barely audible whisper. Such an approach would endorse governmental authority to compile a list of subjects about which false statements are punishable. Yeah, I mean, right. That is sort of the problem at the end of the page, at least in part for the Supreme Court, right? If they can ban you making the claim about the Medal of Honor in its naked form, just merely saying, I have the Medal of Honor. If that itself can be illegal, what else can they make illegal, right? Because it never stops. That's the thing, right? It never stops in our system of government. The slippery slope isn't so much a fallacy as a prophecy in the common law system. So it will never stop with the one thing. That is why, many a bad law was made with bad facts, because the bad facts spurned us to do something to fix the problem, and then we fix the problem in a way that caused more problems. So as a result of that, we are cautious because we know it has no end. It never does. Thus, disavowing Oceania's Ministry of Truth, Justice Kennedy rejected any rule that would give government a broad censorial power unprecedented in this court cases or in our constitutional provision. The mere potential for exercise of the power casts a chill the First Amendment cannot permit if free speech, thought, and discourse are likely to remain a foundation of freedom. And then there is a quote here from Abrams versus United States that says, the remedy for speech that is false is speech that is true. That's what Justice Brandeis also said in my favorite opinion of all time, Whitney versus California. Same idea. The remedy for bad speech is more speech, not enforced silence. Justice Holmes says the same thing. The remedy for speech that is false is speech that is true. This is the ordinary course in a free society. The response to the unreasoned is the rational. To the uninformed, the enlightened. To the straight-out lie, the simple truth. The theory that our Constitution is the best test of truth is the power of thought to get itself accepted in the competition of the market. Free speech and thought flows not from benefits of the state, but from the inalienable right of the person. And suppression of speech by the government can be made exposure of falsity more difficult, not less so. Yeah, all those things for sure. The ends are not well served when government seeks to orchestrate public discussion through content-based mandates. Yep, all those things. Only a weak society needs governmental protection or intervention before it pursues its resolve to preserve the truth. Truth neither needs handcuffs nor a badge for vindication. Yeah, this is basically the same thing that Brandeis said, but Brandeis said it better. But yeah, this is the same idea, right? Freedom of speech. The best remedy for bad speech is more speech, not silence. The best remedy for falsehood is truth. The best remedy for the bad is the good. right? Not to suppress the bad, but to encourage the good. This is the same idea. Brandeis wrote it better. Justice Breyer's two-justice concurrence in Alvarez likewise endorses the same point. Quoting Justice Alito for the proposition, there are two broad areas in which to attempt by the state to penalize purposely false speech would present a grave and unacceptable danger of suppressing truthful speech, which includes laws restricting false statements about philosophy, religion, history, the social sciences, the arts, and the like. These topics, which are often the subject of vigorous public debate, rarely have clear or verifiable answers, hence the controversy, and therefore citizens must be given breathing room to speak their minds without fear, as of here, of criminally being prosecuted by government officials that do not like what they have to say. Yeah, all those things, for sure. Indeed, Justice Breyer concluded that the threat of criminal prosecution for making false statements can inhibit the speaker from making true statements, thereby chilling a kind of speech that lies at the First Amendment heart. Yeah, that is sort of the problem, right? The chilling effect is very, very real, right? If you are prohibited from saying false things, then the prudent person will probably try not to dance on the edge. Because, dancing on the edge is always dangerous legally because you can fall off. So the prudent person will try to stay away from the edge. But of course, the problem is then you're giving up more speech than you have to, because the boundaries are all the way to the edge. But if you won't go to the edge, then the actual boundary is even narrower still. So the chilling effect is almost inevitable to at least some degree. Every lawyer worth their salt, will basically try to give themselves a little margin. Not for the least of reasons is that the lawyer doesn't necessarily know how other people think about it. And so asking a lawyer exactly where the edge is always a dangerous proposition, because you never know exactly how someone else is going to look at it. So the reasonably prudent lawyer is in most situations, almost all situations, going to advise their client to give themselves some breathing room so that we don't have to figure out exactly where the edge is. Because one way to figure out exactly where the edge is by falling off, and that's really bad. So we'll try to avoid that problem. But of course, in the context of the First Amendment, that means that you're giving up more speech than you have to, and that's a real problem. And whatever else can be said is that Donald Trump has as much freedom of speech as anyone else. He has no more, but he has no less. So that is, pretty powerful there. Justice Alito's three-justice dissent in Alvarez, the opinion least protective of speech in that case, endorsed the same conclusion. So what they're trying to do is basically saying, no matter how you try to count to five, I win. All right, least common ground to get to five. Yeah, so good stuff. As the noted above, Justice Alito's dissent recognized that there are broad areas in which any attempt by the state to penalize purportedly false speech would present a grave and unacceptable danger of suppressing truthful speech. Laws restricting false statements about philosophy, religion, history, the social sciences, the arts, and other matters of public concern would present such a threat. The point is that not that there is no such thing as truth or falsity in these areas, or that the truth is always impossible to ascertain, but rather it's perilous to permit the state to be the arbiter of truth. Yeah. Because even if we can all agree, sometimes giving the state that kind of power is problematic because, well, it probably won't be limited to such situations, right? It won't be limited to such situations where we all agree. The state, as always, tries to take more power for itself, always, of course, for the best of reasons, I'm sure. But the problem is that power can be wielded both for good reasons and bad. So government always acquires power for the best of reasons, don't you know? But how they use that power can sometimes raise some difficulties, for sure. Even if there's a wide scholarly consensus concerning a particular matter, the truth is served by allowing that consensus to be challenged without fear of reprisal. Today's accepted wisdom sometimes turns out to be mistaken. Yeah, that's true. We could point to any number of episodes throughout history in which the consensus was ultimately wrong. So challenging the consensus is often valuable. And in these contexts, even a false statement may be deemed to be a valuable contribution to the public debate because it brings about a clearer perception. Thank you, Alan Parker, for the 20 gift memberships. As always, your thoughtful contributions are, as always, extensively appreciated. Thank you. In addition, allowing the state to prescribe false statements in these areas also opens up the door for the state to use its power for political ends. No, you don't say. You don't say, right? It would never be the case that they would use this power for political ends. You know, no bureaucrat, no politician would look at this big shiny button that would fix all their problems and press it ever, because that would be wrong. They'll never press the big shiny button. Yeah. If some statement about historical events may be banned, how certain must it be a statement is false before the ban must be upheld? And who should make the calculation? Who decides is always a problem, for sure. While our cases prohibiting viewpoint discrimination would fetter the state power to some degree, the potential for abuse in power in these areas is simply too great. We don't trust the state in this area. The First Amendment is special. Get off our lawn. Thus, Alvarez reflects the Supreme Court's unanimous consensus that claims about widely disputed social, political, and historical questions that are a matter of public concerns are protected by the First Amendment regardless of the government's view of the supposed truth or falsity. In fact, as Justice Alito's discussion demonstrates, such claims are protected by the First Amendment, especially where the government deems them false. Yeah, I mean, as always, you don't need the First Amendment if you agree. The First Amendment as a concept only truly has value if there's disagreement. If the government says it's true and you say it's true, you don't need the First Amendment. If the government says it's false and you say it's false, you don't need the First Amendment. You only need the First Amendment if you disagree with the government. If you agree with the government, you don't need it. Not to say that you don't have the First Amendment. You don't need the First Amendment, right? You have the First Amendment to agree with the government. If you agree with the government, you agree with the government. It is okay to agree with the government. You just simply don't need it. You have it, but you don't need it because you agree. You only need it if you disagree. Yeah. The conclusion, the First Amendment fully protects opinions and claims on wide dispute and historical issues, such as integrity of the 2020 presidential election, draws further support from the most basic principles of the Supreme Court's First Amendment jurisprudence. Such claims include core political speech on matters of enormous public concern where the speech constitutes forbidden viewpoint discrimination. Yeah. Speech on matter of public concern is at the heart of the First Amendment protection. That is because speech concerning public affairs is more than self-expression, it is the essence of self-government. Accordingly, speech on public issues occupies the highest rung of the First Amendment values, also entitled to special protection. Yep, that much too, right? Not all speech is necessarily worthy of the same level of protection in the First Amendment hierarchy. Some speech is more valuable than others. The most valuable speech is political speech because it is the speech that goes to the nature of the government. The First Amendment's point or principal concern is in the issue of expressing political speech, the very speech that the government might have the strongest interest to disagree with. So movies are fine and all, movies can be entertaining, or book can be entertaining, or, whatever. But the most important speech is the political, because it goes to the very heart of the First Amendment area. So that makes total logical sense, of course. Accordingly, speech on public issues occupies the highest rung of the hierarchy of the First Amendment and is entitled to special protection. Speech deals with matters of public concern when it can be fairly considered as relating to any matter of political, social, or other concern of the community, or where it's a subject of legitimate news interest, that is, a subject of general interest and value and concern to the public. And Justice Alito's dissent in Alvarez explicitly states the areas where the First Amendment does not permit criminalization of supposedly false statements that can be summarized as those involving matters of public concern. Speech disputing the outcome of the 2020 election unquestionably constitute speech on matter of public concern. Yeah, this is really good stuff. I really like the way that they're writing these First Amendment arguments. They're very, very good. And it is very arguable that this is what's going on in this case. These are very broad principles. So if I had to fault the document so far, I would say I fault it slightly for not applying these principles to the case at hand, because they're just stating these things that are truisms, but they're not stating how these necessarily apply to the immediate case. Maybe they'll get a little bit more into that later. But this is all really good stuff. I like the way this is written. This is very good. Core political speech. Indeed, such speech constitutes core political speech, and the First Amendment protections as a zenith when the government attempts to restrict core political speech. True. No form of speech is entitled to greater constitutional protection than core political speech. This is especially true of speech relating to elections, since the First Amendment's constitutional guarantee has the fullest and most urgent application precisely to the conduct of campaigns for political office. Very true. Thank you, Vanessa Smith, for the 20 gift memberships. Your contribution to the channel is extensively appreciated. Thank you. Viewpoint discrimination. Further, attempts to prohibit or criminalize claims of political dispute, such as the integrity of the 2020 presidential election, inevitably target speech on the basis of viewpoint discrimination, which is the least tolerable of the First Amendment violation. It's axiomatic that government may not regulate speech based on its substantive content or the message it conveys. Viewpoint discrimination is bad. The government can't allow some viewpoints and not others. Right? The government may potentially be able to restrict subjects under strict scrutiny. But once you allow the discussion of the subject, you have to allow all viewpoints on the subject. That's sort of the ultimate bottom line there. When the government targets not the subject matter, but rather particular views taken by subjects, the violation is all the more blatant. Right. It may be proper for the government to restrict subject matter. For example, if you're at a school board meeting, it would be a bad time to start raising issues about the DMV. Your issues about the DMV probably would be better expressed in a different venue, right? So just as a silly example, or issues about your HOA, right? I mean, those might be valuable things to complain to the government about, but not at the school board meeting. That's not what that meeting is for, right? But if you want to talk about the educational curriculum, hey, that sounds like something that's much more appropriate for a school board meeting. And whatever your views on the topic are, you must be allowed to express those views, because that is all good and right. Viewpoint discrimination is thus an egregious form of content discrimination. The government must abstain from regulating speech where the specific motivating ideology or the opinion or perspective of the speaker is the rationale for the restriction. Outstanding. The fact that the indictment alleges that speech at issue was supposedly, according to the prosecution, false makes no difference. Under the First Amendment, each individual American participating in a free marketplace of ideas, not the federal government, decides for him or herself what's true or false on great disputed social and political questions. As noted above, our constitutional tradition stands against the idea we need Oceania's Ministry of Truth. Well, that's the third time they're saying it. It's lost its power a little bit, so Permitting the government to decree this false speech to be a criminal offense would endorse the government's authority to compile a list of subjects about which false statements are punishable. That governing power has no clear limiting principle. That's a problem, right? If you can't find the limits, that's often a problem in law, to be sure. Thus, falsity alone may not suffice to bring the speech outside the First Amendment. Absent from those few categories where the law allows content-based regulation of speech is any general exception to the First Amendment for false statements. When you're thinking about content-based regulation of speech not protected by the First Amendment, of course, you're traditionally thinking about fighting words, libel, slander, that kind of stuff. But you're not thinking about just stuff that happens to be false. right? That's not, false is not a general category exception. This comports with the common understanding that some false statements are inevitable if there's to be an open and vigorous expression of views in public and private conversation in the First Amendment that it seeks to guarantee. This is very well written. Check 1, 2. Yeah, sorry of the, thank you for letting me know the mic went out. That happens from time to time, and it's really annoying. The indictment here does not merely criminalize conduct with incidental impact on protected speech. Instead, it directly targets core speech and activity. Yeah. And for this reason, it's categorically inactive. All right. Clearly, the government has no power to restrict speech because of the message. All right. For a similar reason, the indictment is invalid under any level of scrutiny. As noted above, the indictment imposes a viewpoint-based restriction on core political speech on matters of the highest public concern, with extremely severe penalties, and thus, if any scrutiny applies, it's the strictest form of scrutiny. Yet, regardless, the prosecution cannot show any interest, let alone compelling or substantial one, in punishing the First Amendment protected activity. Okay. Yet regardless, the prosecution cannot show any interest, let alone compelling one, in punishing the First Amendment activity. The prosecution has no valid interest in silencing disfavored viewpoints or preventing people from advocating such disfavored viewpoints to governmental officials. The indictment is precisely tailored to violate free speech rights, not narrowly tailored to avoid them. This is the antithesis of narrow tailoring. Finally, if the indictment validly applies the language of the statute, that renders the statute both unconstitutional as applied and unconstitutional on its face under First Amendment overbreadth doctrine. Probably not, but it never hurts to mention it, right? You might get somewhere. I wouldn't bank on it, but under the prosecution's interpretation, the statute sweeps in the criminalization of large amounts of pure speech and thus suffers from overbreadth that is not only real, but substantially as well judged in relation to the statute's plainly legitimate sweep. Yeah, I wouldn't think, I don't know about that on its face, the facial challenge. The as applied challenge is much more promising than the facial challenge, but I suppose you read that issue. All right. Because the First Amendment confers an absolute protection on public statements about hotly disputed societal, political, and historical topics and other matters of public concern, including those which are supposedly false, it confers the same protection on those statements made in advocacy for government officials to act on one's views. The First Amendment protects the right to petition the government for redress of grievances in the same clause as the freedom of speech. It sure does. I'm not sure why it's necessarily like important that it's in the same clause or not, but it does. I mean, I view them as two separate things. I suppose they're related things, but they're distinct things, to be sure. Yes, law talk with my facial challenge. That is exactly what we're talking about. You are correct, sir. Glad to have you in chat as always. When it comes to what speech is protected, the right to petition is coextensive with the right to speak. A claim protected under the amendment's right of freedom of speech is equally protected when the same claim is made while petitioning the government. As the Supreme Court has stated, the right to petition is cut from the same cloth as other guarantees of the amendment, as assurance of particular freedom of expression. Yeah. For this reason, in McDonald, the Supreme Court consulted the right of freedom of speech to determine what states are protected when exercising the right to petition the redress of government. McDonald concerned a libel lawsuit brought about a man who sent letters to President Reagan making allegedly libelous claims about a potential political appointee. The libel defendant claimed he had absolute immunity from libel suit because the allegedly libel statements were made in the course of petitioning the government. The Supreme Court rejected this claim, holding instead the scope of the First Amendment protection for claims made while petitioning governmental officials is coextensive with the scope of the First Amendment protection for public statements under the Free Speech Clause. Okay. Because libel falls within a well-established First Amendment exception, libel made in statements to the government officials is likewise unprotected under the petition clause of the First Amendment. Okay. In so holding, the Supreme Court has made clear that the free speech clause and the petition clause are on identical footing, establishing the same levels of protected speech. To accept petitioner's claim of absolute immunity would elevate the petition clause to special First Amendment status, which incidentally isn't necessarily something I would oppose necessarily in the first instance, but whatever. The petition clause, however, was inspired by the same ideas of liberty and democracy that gave us freedom to speak, publish, and assemble. These First Amendment rights are inseparable, and there's no sound basis for granting greater constitutional protection to statements made in petition to the president than other First Amendment protection. Yeah, I'm not sure if I necessarily agree with that, but that's what the Supreme Court said, so fine. The same logic applies here. Just as there's no sound basis for granting greater protection to statements made in a petition than other First Amendment expression, so also there is no sound basis for granting lesser protection to the same statements. After all, the petition clause reflects the same ideas of liberty and democracy that gave us the freedom to speak, publish, and assemble. Thus, speech that is protected by the free speech clause when made in a public forum retains its full amendment when made to the government in the ordinary course of petitioning them. Yeah, it's good stuff. Shared the stream to X, good stuff. Hopefully this is streaming in X. I set up multi-streaming. I don't know if it's actually working, but if it is working, I'm simul-streaming to YouTube, Facebook, X, and Twitch all at once. Ooh, fancy. We're experimenting. Also, I think possibly TikTok. This may be also streaming to TikTok. I'm not sure. I don't even know where this is streaming right now. It may be streaming many places. This conclusion draws further support for McDonald versus United States. In McDonald, the government prosecuted the governor of Virginia using an interpretation of the phrase official act that would have criminalized a broad range of ordinary political lobbying of public officials. Section 201 prohibits quid pro quo corruption, the exchange of a thing of value for an official act. In the government's view, nearly anything a public official accepts, from a campaign contribution to launch, counts as quid, and nearly anything the public official does, from arranging a meeting to inviting a guest, to event, counts as a quo. The Supreme Court unanimously held that in addition to being inconsistent with both text and precedent, the government's expansive interpretation of official act would raise significant constitutional concerns, precisely because of how it threatened to criminalize a broad range of ordinary activity done in furtherance of petition of the governments under the First Amendment. I don't even know what's going on right now. Let's see if I'm live on TikTok. I might be live on TikTok. I'm not even sure what's going on right now. I don't think so. No, maybe not. Okay. Anyways, carrying on. Conscientious public officials arrange meetings for constituents, contact other officials on their behalf, and include them in events all the time. The basic compact underlying representative government assumes that public officials will hear from their constituents and act appropriately on their concerns. The government's position would cast a pall of political prosecution over these relationships. Officials might wonder where they could possibly respond to, even in complex requests for assistance, and citizens with legitimate concerns might shrink from participating in the democratic discourse. Yeah. That sounds all right to me. We don't have OnlyFans yet, but maybe later. That comment comes courtesy of Twitch. Hello, Twitch people. And Facebook, we got, I got multi-chat built in. So we got Alex on Facebook. So that's nice, chatting to me. And then we've got Joshua on Twitch chatting to me. And then we got a whole bunch of YouTube people chatting to me. Hey, so we at least got 3. That's nice. Am I on X too? I don't even know. I don't even know. Am I on X too? Let's see. Yep, apparently. There's even 6 of you watching on Twitch, or 6 of you watching on X. Ooh, exciting. Exciting. Mike Johnson has been elected Speaker of the House. Huzzah, we have a new speaker, man. Put up the wife puffs of smoke, man. Put up the wife puffs of smoke, man. Good shit. Anyways, carrying on with the actual stream, now that we figured out all the places we're streaming simultaneously. That's cool. Let's see. Permitting prosecution to criminalize First Amendment protected statements simply because they were made to the government would violate the basic compact of representative government and cause citizens with legitimate concerns to shrink from the democratic discourse. Consider any number of disfavored claims on a host of controversial topics, all deemed to be demonstrably false and disinformation by the government at various times, such as claiming that masks do not stop the transmission of COVID-19, which, that vaccines don't stop the transmission of COVID-19, which also, that COVID originated from a lab in Wuhan, China, and that the 2020 presidential election was stolen. I like that list. That's very cute. That's very nicely put. Can the government prosecute a citizen for attempting to defraud the United States by making supposedly false statements to the government, for opposing mask mandates by telling legislatures they don't stop transmission, opposing vaccine mandates by telling legislatures they don't stop transmission, and or urging the investigation of China by telling government officials that COVID-19 leaked from a lab? Under the First Amendment, the answer is no, and absolutely applies to the president's claims that the election was stolen. I like that list. That's cute, because those were all positions, of course, that the government didn't want to hear and may have tried to censor, possibly using their social media partners at times. So all those good things. Yeah. Thus, under the First Amendment, the prosecution cannot criminalize claims that the 2020 presidential election was stolen, and it cannot by prosecution seek to impose its view on a disputed political question like the integrity of the 2020 election. I think some of this is also applicable to the Georgia case. By the way, incidentally, probably tomorrow, it won't be today at this point, it's too late, but tomorrow probably I'm releasing another video on the Georgia case that's in the new edited style, and I really hope that you like it. I spent a lot more time going over the background of RICO and how we got here sort of in RICO land and how things are going, and trying to talk about the case a lot more. So all the things. So please look forward to that. It should be a really good video. I hope you'll like it. If there's any fixed star in our constitutional constellation, it can be that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or in other matters of opinion. Kick ass. At the heart of the First Amendment lies the principle that each person should be to decide for him or herself the ideas and beliefs deserving of expression, consideration, and adherence. Neither the federal executive branch nor the judicial branch, both of which are bound by the First Amendment, may dictate such claims are criminally false. Claims about the integrity of the 2020 presidential election, including claims that the election were rigged and or stolen, or that fraud and irregulatories, damn it, can't pronounce that word today, regulatories, bad things, tainted the outcome in certain states or across the nation, implicate all the fundamental First Amendment principles discussed above. They constitute core political speech, expressing a specific disfavored viewpoint on matters of enormous public concern that relate to a widely disputed historical, social, and political question that is not readily verifiable or falsifiable. Thus, they lie at the heartland of the First Amendment protection, and the federal government may not dictate where such claims are true or false, nor prosecute the purveyors of the allegedly false views. Irregularities. Yeah, there you go. That's the right one. Psycho Boy, thank you. I'll probably screw it up next time, but I'm trying. Today's not my day, man, for that word. This is especially true because claims that the 2020 election were rigged or tainted by fraud and irregulatories, damn it. Unlike the pliable claim at McDonald, do not involve easily verifiable facts. Such claims require the assessment of mountains of information from which each person will draw competing inferences based on the facts. I know I can speak English. I'm a native English speaker, damn it. I'm extremely well educated. It's not my day. It's just not happening. It's not going well for Uncivil. Based on their facts as personally deep-seated political views and presuppositions. They are not readily verifiable or falsifiable. They relate to politically charged issues, and people's assessment of them is deeply linked to their political predispositions and trust in institutions, including governmental institutions. This is why American opinions on the issues are profoundly divided, very much to this day. The First Amendment does not permit the prosecution to dictate what is true and what is false on such broad, vigorously disputed, politically charged questions, especially not in the context of a criminal prosecution that effectively seeks to criminalize a political viewpoint shared by over 100 million Americans. Good times. Yeah. Thank you, Parabellum, for the 5 gift memberships. Your contributions to the channel are extensively appreciated. Many millions of people believe that the 2020 presidential election was unfairly rigged against President Trump. $5 super chat from Matthew Mado. Absurd reduction because I'm absurd. Voting is the quid. Voting is the quid. Promotion of one's politics is the quo, since voting is 1A. That's very cute, Matthew. I like that. I appreciate your example. Many of millions of people, of reasonable people, believe the 2020 presidential election was unfairly rigged against President Trump and that fraud or other, where's my pronunciation guide? Irregularities tainted the election results. There is an abundant public evidence providing a reasonable basis for these opinions. What is critical is how one interprets this evidence dependence on one's deep-seated political views, including one's trust in government and the governmental officials, among others. Different people will draw different inferences from such public evidence based on deep-seated political views, and that's exactly what the First Amendment permits, even celebrates. I like this. This is good stuff. The unconstitutional dynamic appears on the face of the indictment itself. Okay, so now we're getting a little bit more into the application to the case at hand, because I feel like we need to ground this a little bit more. These are all great ideas. They're all true. They're all high-level ideas, and I appreciate that, and they're all great. but we need to ground this now. We need to ground this in the particulars of what's going on, because, like, yes, all these wonderful First Amendment principles are great, but you need to make it more explicit how it applies here. And so it looks like we're getting a little bit more into that. So hopefully we're going to ground this a little bit more at this point. This unconstitutional indictment appears on the face of the indictment itself. The indictment repeatedly alleges that President Trump made knowingly false claims of election fraud. But in every case, the indictment's basis for the allegation that President Trump's claims were knowingly false is that a member of the political establishment assured President Trump that they're false. That's very good. That's very true. Under the First Amendment, President Trump and his supporters are entitled to mistrust the worst word of such establishment-based government officials and draw their own inferences from the facts. And neither the federal executive branch, through its prosecution, nor the judicial branch, through this court, may dictate what President Trump and others are required to believe or say about this hotly disputed political question. But then there might be a question of fact as to what he actually did believe. Like, they can't say what he is required to believe, but a jury might be able to find what he did believe. There's a distinction there. Right, so. Anyways, the prosecution, of course, may come to its own conclusion about such matters. It may hold hearings and conduct investigations to try to establish its own view and convince others of them. It may insist that the opinions of others, including President Trump, are wrong, baseless, stupid, even false and malicious. But it may not require Americans to subscribe to its views or punish them for expressing and advocating for different views. To do so would violate the First Amendment. Under the First Amendment, the question of whether the 2020 presidential election was stolen from President Trump must be decided in the marketplace of ideas, non-criminal prosecution. All right. So my criticism here is, at least for my taste, this is not, it could have been better grounded in things going on here. They kind of skirted, at least in my mind. They spent too much time in theory and not enough time in application. What they did in theory was really great, and I really liked what they did in theory. But what they didn't do, at least in my view, was ground this enough in the facts of this case. And they touched on it a little bit. You saw them touch on it a little bit, but the amount was not proportionally satisfying. It was not quite. Yeah. Igama says, is it possible? Do we allow juries to determine what people believed? Sure, because it goes to what someone knew. And what they know goes to what they believe. So sure, we do it all the time. Yeah. So the facts, so the application of the facts is a little bit unsatisfying. All right, and then they get into this argument, which I don't really think goes anywhere, but we'll give it a shot for a while. They get into this argument about whether or not his acquittal in the Senate bars criminal prosecution, which I don't think so, but we'll give it a shot anyway. The indictment must be dismissed because President Trump was impeached, tried by the Senate, and acquitted on articles of impeachment that arise from the state's court's conduct as criminal indictment. Under our separation of powers, the executive branch lacks authority to second-guess the decision of the legislative branch on an issue that lies within the legislative branch's power, exclusive purview. Well, impeachment lies within their exclusive purview, that's true. But this is an impeachment, so that doesn't quite work. The Constitution's plain text, structural principles of separation of powers, and our history and tradition and principles of double jeopardy bar the executive branch from seeking to recharge and retry a president who's already been impeached and acquitted in a trial before the U.S. Senate. The text of the Constitution straightforwardly provides that only a party convicted by the Senate may be charged by indictment, trial, judgment, and punishment, not a party acquitted. As the Senate acquitted President Trump, the prosecution may not retry him in this court. To remove him from office, the president must be convicted in a trial of the Senate, which is exclusive authority over Constitution versus trials. The Senate shall have the sole power to try all impeachments, and no person shall be convicted without the concurrence of 2/3 of the members present. Sure. Judgment in cases of impeachment may not extend further to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. That's an interesting way to read the Constitution. I don't blame them for trying. That's an interesting way of trying. Yeah, the party convicted shall nevertheless be, but what about the party acquitted? Yeah, so the Constitution's a little bit silent on the issue. That's an interesting way of reading the Constitution. I don't think I agree with them, but I appreciate the effort. Because the Constitution specifies only the party convicted by trial in the Senate may be liable and subject to indictment, trial, judgment, and punishment, it presupposes that the president who's not convicted may not be subject to criminal prosecution. As Justice Alito noted, the plain implication of the phrase the party convicted in this clause is that criminal prosecution, like removal from the presidency and disqualification from other offices, is a consequence that can come about only after the Senate's judgment, not prior to or prior to the Senate's trial. While he's president, I would agree, but I'm not sure I agree after the fact. It's an interesting read, though. That was how Hamilton explained the impeachment provisions in the Federalist Papers. He wrote that a president may be impeached, tried, and upon conviction would afterwards be liable for prosecution and punishment in the ordinary course of law. Justice Alito's interpretation of the clause is well-founded. The long-standing canon of interpretation expressio unius est exclusio alteris, the expression of one is the exclusion of the alternates, reflects the principle that specification of one implies the exclusion of other validly describes how people express and understand verbal expression. When a car dealer promises a low financing right to purchasers with good credit, it's entirely clear that the rate is not available to purchasers with spotty credit. Well, at least your odds of getting it are lower. I mean, it's not impossible, but it's not what that they're offering, right? I promise to give good rates to anyone with good credit isn't necessarily saying I won't give good rates to people without good credit, but certainly not saying I will. So, yeah. So as here, when the Constitution provides the party convicted in the Senate may be subject to criminal prosecution, it's entirely clear the party acquitted in a Senate trial is not subject to criminal prosecution for official acts. This is true because the phrase the party convicted can be reasonably thought to be an expression of all that shares in a grant or prohibition involved. Because there's only two possible outcomes from a Senate trial, conviction or acquittal, specifying the implications of one clearly means the others do not apply. You know, I don't mind them making this argument. You know, even if I disagree with it, it is not frivolous. It is based on text. And, you know, I like that. And the ideas that they're playing with certainly are ideas that can work. I'm not blown away in the first instance, but maybe if I think about it more, I'd be more convinced. I could see myself being convinced by this line of argument. So I wouldn't say that I'm convinced right now, but maybe if I chewed on it more, I'd think about it more. But yeah, this is, you know, an interesting idea. I'm not sure if I agree with it, but I mean, they've got a basis to make the argument. And as a lawyer, that's all you really need, right? It's like, you know, you have a basis to make the argument, so you make the argument. You know, if I were clever enough to think of it, I'd make the argument. Doesn't necessarily even mean I agree with it, but, you know, it's for my client, right? The interpretation reflects original public meaning of the impeachment clause. James Wilson, who had participated in the Philadelphia Convention, at which the document was drafted, explained that, although the president is amenable to laws in the private character as a citizen, and his public character by impeachment. With respect to acts taken by public character, that is official acts, the president may be disciplined by principles and by impeachment. Okay. Yeah, all right. In addition, in Federalist 43, James Madison indicated the concerns about politically motivated prosecutions led to the adoption of the definition of treason. As treason may be committed against the United States, the authority of the United States ought to have been enabled to punish it. But as newfangled and artificial treasons have been great engines by which violent factions, the natural offsprings of free government, have been usually wreaked by their natural alternate malignity on the other side, the Constitutional Convention had, with great judgment, opposed a barrier to this peculiar danger by inserting a constitutional definition of the crime, fixing the proof necessary for conviction of it, and by restraining Congress, even in punishing it, from extending the consequences of guilt beyond the person of the author. No corruption of blood. The Federalist 47, that was from the Federalist 47. In the Federalist 65, Alexander Hamilton explained the Constitution entrusted impeachment trials to the Senate because of the risk of politically motivated criminal trials, which would be inevitably tainted by factionalism and partisanship, was too great for the courts, including the Supreme Court. A well-constituted court for the trial of impeachments is an object not more to be desired than difficult to obtain in a government wholly effective. The subject of the jurisdiction are those offenses which proceed from the misconduct of public men, or in other words, from the abuser or violation of some public trust. They are of a nature which may be peculiarly propriety be denominated political, as they chiefly relate to injuries done immediately to society themselves. Well, impeachments are political. I agree with that. I've been telling you that forever. The prosecution of them for this reason will seldom fail to agitate the passions of the whole community and divide it into parties more or less friendly or inimical to the accused. In many cases, it will connect itself with pre-existing factions and will list all their animosities, partialities, influence, and interest on one side, or on the other, as in such cases there will always be the greatest danger, that the decision will be regulated more by comparative strength of parties than by real demonstration of innocence or guilt. And that's from Federalist 65. Eric Newman says, when did the Federalist Papers become cited in law? All the time. When you're doing constitutional arguments, all the time. A lot. The awful discretion by which court of impeachments must necessarily have to doom to honor or infamy the most confidential and the most distinguished characters of the community forbids the commitment of the trust to a small number of persons. These considerations seem alone to authorize a conclusion the Supreme Court would have to be an improper substitute for the Senate as a court of impeachment. I would agree with that. I would say that this is not impeachment, but fair enough. Too bad this reasoning has nothing to do with RICO charges. That is true. This is the DC case, as we discussed at the top. So this is just dealing with the case in DC. Although some of this may be applicable to the RICO charges, this is not filed in that case. This is just with respect to the DC charges by Jack Smith. So. In addition, treating impeachment as the exclusive remedy for alleged crimes committed in office is consistent with the Supreme Court's immunity decisions as to other sensitive officials, such as federal judges. The Supreme Court has held that judges are absolutely immune from civil liability and criminal prosecution for their official acts, and the sole remedy is impeachment. So this is all being dependent on them being his official acts. So if you think that these are all his official acts, then I would say he has absolute immunity. But I'm not sure that that's how it's characterized, but okay. The Supreme Court held that judges are absolutely, we read that part, but for malice or corruption in their action whilst exercising their judicial function within the general scope of their jurisdiction, the judges of these courts can only be reached by public prosecution in the form of impeachment. With respect to their official acts, I would agree. So if we think that these are all official acts, then I would agree. Then he has immunity, and I would say that. Arctic, as to multi-streaming with Twitch, they just changed their policy in the last week. So yeah, Twitch just changed its policy. It's new. So, yay. In Nixon versus Fitzgerald, the Supreme Court reinforced this conclusion by emphasizing that the proper remedy against the president for official malfeasance is the threat of impeachment, not criminal prosecution. A rule of absolute immunity for the president will not leave the nation without sufficient protection against misconduct on the part of the chief executive. There remains a constitutional remedy of impeachment. In addition, there are formal and informal checks on presidential action. The president is subjected to constant scrutiny by the press. Vigilant oversight by Congress may also serve to deter presidential abuses of office, as well as to make credible threats of impeachment. Other incentives to avoid misconduct may include a desire to earn re-election, the need to maintain prestige as an element of presidential influence, and the presidential traditional concern for historical stature. Yes, so now Uncivil can now multi-stream to Twitch, which Uncivil is very excited about. So this will hopefully help us get whole new audiences, exciting and fun. So yeah, and you can also, for those of you who have Amazon Prime, remember you can subscribe on Twitch for free. So that gives me money. So I like money. So if you have Amazon Prime and you have Twitch, you can use your Amazon Prime to subscribe to me for a month, and then I get money. And it doesn't cost you anything, and I get it from Jeff Bezos. So that's nice. Here, President Trump is not a party convicted in the impeachment trial by the Senate. In January 2021, he was impeached by the House on articles arising from the same course of conduct at issue in the indictment. Okay. Among other things, the articles of impeachment charge that President Trump repeatedly issued false statements asserting that presidential election results were the product of a widespread fraud and should not be accepted by the American people or certified by state and federal officials. Made false claims in a speech on January 6, engaged in prior efforts to subvert and obstruct the certification of the result of the 2020 election, including through a phone call to the Georgia Secretary of State, and threaten the integrity of the democratic system. The indictment here rests on the very same alleged facts. President Trump was acquitted of these charges after trial in the Senate. He is thus not a party convicted, and is not subject to indictment for the same course of conduct. It's not bad. It's not bad. I'm not sure I agree with it, but it's not bad. It's nice. Yeah. In sum, under the Constitution, the executive branch, including prosecution, lacks authority to second-guess the determination of acquittal made by the United States Senate, the body to which the Constitution expressly entrusts authority. To do so violates the impeachment clause and principles of separation of power by unlawfully encroaching on authority exclusively invested in Congress. The founders of the nation entrusted the impeachment power to Congress alone, both in good and bad times. Okay. I mean, it's an interesting line of argument. There is text to support it. I'm not sure it's the right way to read it, but, you know, they have the basis for the argument, so I don't mind it. It's fine. All right, let's see what else we got. The prosecution's barred by principles of double jeopardy. Okay. Applying principles of double jeopardy leads to the same conclusion. The Fifth Amendment says, nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb. Yeah, the problem here is that the impeachment doesn't lead to jeopardy of life or limb, because the only possible penalty from the impeachment itself is being thrown out of office. So that's why the double jeopardy clause doesn't apply, because you're not in jeopardy of life or limb. So, yeah. The clause presents the same sovereign from subjecting a defendant to multiple sequential charges based on the same operative facts or the same course of conduct. Under those principles, the prosecution cannot proceed against the president for conduct that is acquitted in the Senate. Yeah, that argument doesn't work, I don't think. But that's okay. The fact that different branches of government are issue makes no difference. That part is true. In addition, in applying the dual sovereign doctrine, the critical determination is whether the two entities that seek to prosecute can be termed separate sovereigns. They're not. That part's fine. Invisible Puma says, in the few streams you host and provide commentary on Supreme Court oral arguments, would you consider doing the same for U.S. Circuit Courts? I believe we have on a couple of occasions done it for U.S. Circuit Courts. If there's a particularly interesting one that, will enrapture a large audience's attention, then sure. I will go anywhere the views are within the law, right? I'll go anywhere the views are within the law. So if there is a particularly interesting appellate argument, then sure, I'll cover it before. We've done it before. We'll do it again. The states are no less sovereign with respect to each other than they are with respect to the federal government. Their powers to undertake separate criminal prosecutions derive from separate and independent sources of power and authority originally belonging to them before the admission of the Union and preserved to them by the 10th Amendment. The same is not true, however, with respect to different branches of the federal government, all of which derive their power from the same source. Thus, the executive and judicial branches cannot seek to place him in jeopardy for conduct in which the legislative branch has absolved him. Yes, they can, because he wasn't in jeopardy of life or limb. Right? So, the same reason he could be sued, I think. The government, through Congress, already put him on trial once, placing him in jeopardy, but not for life or limb. For an alleged criminal offense, it was political offense. For the same course of conduct. Yeah, that one I don't buy. So I won't give him the double jeopardy argument, but I appreciate him trying. The indictment charges President Trump with crimes arising from political advocacy on matters of public concern made in the middle of a disputed presidential election. President Trump's actions were inspired by and fully consistent with examples from many similar contested election disputes on our nation's history. There's a long history in our nation dating back to the 1800s and encompassing elections in 1800, 1824, 1876, 1960, 2000, 2004, 2016, among many others, of disputing the outcome of close presidential elections, publicly claiming that election results were tainted by fraud, following legal actions to challenge election results, lobbying Congress to decertify disputed election results in one side's favor or the other, and organizing alternate contingent slates of electors to assist in such efforts. In other words, all the chief alleged acts in the indictment have a long historical pedigree in the American electoral history, and they've long been decided in the political arena. President Trump is the first person to face criminal charges for such core political behavior as disputing the outcome of the election. He's charged, moreover, under statutes that facially have nothing to do with the alleged conduct, and whose language the special prosecutor stretches beyond recognition. As a result, President Trump could not possibly receive fair notice. We'll skip this one for the moment because this relies on statutory arguments, which are in a different brief. So we will skip that for the moment because the conclusion here would flow from the statutory arguments. So we'll skip all that. And that is the end of that one. Okie dokie. That was all fun and exciting. All right. So, excuse me. Thank you to the 456 of you currently watching, by the way. I just want to thank each one of you who are here to be part of this stream, and I really do appreciate it. Hope that you're learning something about the law and hope you appreciate the legal analysis. I always aim to give good quality content, and I appreciate everyone who helps to support the channel. It helps us grow. Let us move on to the next thing. All right, so now we're going to move into the statutory grounds from which the due process argument would flow. So let's see what's going on here. Yeah. Targeting an audience other than the court, the prosecution's indictment in this matter rants endlessly about President Trump's politics, and in a shockingly un-American display of authoritarianism, accuses him of crimes for having and expressing the wrong opinions. Buried at the end of this diatribe are conclusionary statements that President Trump's alleged actions somehow violate the law. Okay. I'm feeling the fire. I'm feeling the fire. That's nice. That's good stuff. The prosecution does not explain exactly how President Trump violated the statute, beyond simply saying that he has while regurgitating the statutory language. As explained here, and the reason the prosecution employed this tactic is plain. President Trump did not violate the statute, even accepting the prosecution's false allegations as true. Accordingly, the court should dismiss the indictment for failure to state an offense. How fun and exciting. In relying on a motion to dismiss for failure to state an offense, a district court is typically limited to reviewing facts of the indictment and more specifically language used therein. When considering a motion to dismiss, the court must review the facts of the indictment, or the face of the indictment rather, and the indictment must be reviewed as a whole and accepted as true in these proceedings. Excuse me. Thank you, by the way, Adam Trapp, for the 20 gift memberships. They are extensively appreciated. President Trump denies the allegations and sets forth the facts alleged in order to do their sufficiency. Great. Count 1 of the indictment charges President Trump with conspiracy to defraud the United States. As relevant here, the statute provides, if 2 or more persons conspire to defraud the United States or an agency thereof in any manner for any purpose, and 1 or more persons do so to effect the object of the conspiracy, each shall be fined. So it's illegal to conspire to defraud. The statute does not define the phrase defraud the United States or provide further textual guidance about the meaning or scope. At bare minimum, however, the statute requires a showing of trickery or deceit, which the indictment does not allege. Further, for cases outside the heartland of financial fraud, that are cases involving fraudulently obtaining money or property, the statute requires an additional showing of obstruction or interference, which it doesn't actually show. Okay. The Supreme Court has long interpreted the word defraud to require not just any false statement, but a showing of trickery or deceit. In Hammerschmidt, the government charged political advocates who opposed the draft for allegedly defrauding the United States by impairing, obstructing, and defeating a lawful function of government in the printing and circulating of handbills, urging others to refuse to register for the draft. In other words, prosecutors relied on broad language of the statute to criminalize advocacy of disfavored viewpoints on a hotly disputed political and societal question. The government argued that the statute is broad enough in its terms to include any conspiracy for the purpose of impairing, obstructing, or defrauding, or defeating the lawful function of government. The Supreme Court rejected this argument, holding the indictment was deficient because the word defraud requires a showing of deceit or trickery, not just advocacy of a viewpoint the government disfavors. Okay, this is more promising. This sounds good. It is obvious that the writer of the opinion of the case and the court were not considering whether deceit or trickery was essential to satisfy the defrauding requirement on the statute. The facts of the case were such the question was not presented. The deceit of the public, the trickery in advance publication secured by bribery of an official, and falsification of reports made the fraud and deceit so clear as to the gist of the offenses actually charged their presence was not in dispute. Thus, the court held the statute's core application is to trick or deceive the government into paying money under false pretense, and this requirement of trickery or deceit applies in all their cases as well. To conspire to defraud the United States means primarily to cheat the government out of property or money, but also means to interfere with or obstruct one's lawful government functions by deceit, craft, or trickery, or at least by means that are dishonest. This requirement of trickery or deceit is well established. Here, the indictment does not allege any acts that constitute deceit or trickery within the meaning of Hammerschmidt. As is relevant here, the indictment alleges 3 types of conduct that were supposedly involved in making the false statement. Claims that the 2020 presidential election were rigged or tainted by fraud or other irregularities, made both in public and communication with public officials, organizing and submitting contingent slate of electors to the President of the U.S. Senate and the Archivist of the United States, and making public claims about the scope of the Vice President's legal authority with respect to the certification. First, the indictment alleges that President Trump claimed the 2020 election outcome was tainted by fraud and other irregularities. It alleged that he made this public. It also alleges that he made such claims in meetings and communications with state officials, DOJ officials, and federal election officials. The indictment also alleges that President Trump made supposedly false legal claims about the scope of the vice president's authority under the Constitution. These claims cannot support an allegation of attempting to defraud the United States under the relevant law. Unlike an ordinary fraud case, the supposedly false claims alleged in the indictment are related to the most publicly visible, vigorously disputed, and widely reported debates of the day, namely, where the 2020 presidential election was rigged or stolen against the president. Whatever one thinks of his opinion on the issue, his assertion does not constitute deceit or trickery. Okay. Every official listed in the indictment unquestionably knew that election fraud and irregularities were and are vigorously disputed topics, and that President Trump's opinion on the subject was just that, an opinion formed based on his view of all the available information. Virtually every American, including cited public officials, had similar access to much of the same information, including a mountain of publicly reported facts and opinions, which were the subject of wall-to-wall media coverage throughout the post-election period and beyond. Each official thus had every opportunity to form his or her own conclusions, just like President Trump. To assert that President Trump, as one voice among countless millions, was somehow capable of unilaterally tricking or deceiving these individuals, which include some of the most informed politicians on the planet. And there's a point there. You know, I appreciate that. That's fine. That's good stuff. Yeah. It is therefore unsurprising this type of conduct, including pure advocacy directed to public officials, bears no resemblance to cases in which the court has found deceit or trickery within the meaning of the law. I mean, yeah, there's a lot to be said there, right? He was expressing his opinion. It's not trickery, I don't think. And it's not really deceit either, because he's just expressing an opinion about what he thinks the facts are. So I appreciate this. This is good. I like this. This is nice. I like this. Rick in chat says former President Trump. As I'm sure you're more than well aware, Rick, it is customary to refer to presidents and former presidents by just calling them president. So you can call him former president, but as I'm sure you're aware, it's very common to say President Carter, President Bush, President whatever, you to refer to them by their last title. It's custom. It's normal. Where the hell is this thing picking up? Okay. In each such case, the defendant's conduct was In each such case, the defendant's conduct was based on concealment and exclusive control of information that raised real risks that government officials might be deceived to the government's detriment. Here, the outcome of the 2020 presidential election, President Trump vigorously advocated his viewpoint on a widely disputed political controversy. If one agrees with the view the election was stolen, to advocate that view does not constitute trickery or deceit. All right, fair enough. Thank you very much, Peter Banyan, for the $3 super chat. Your contribution is appreciated. As noted above, the implications of the prosecution's overly broad view of fraud is staggering. The prosecution's theory would criminalize a group of citizens who oppose mask mandates and insist to public officials that masks are ineffective in curbing the spread of COVID-19, and stoutly adhere to that view, even where CDC studies supposedly contradict it. Such advocates in the prosecution's view would be conspiring to defraud the President of the United States by making supposedly false statements and attempt to influence or obstruct governmental policies. Likewise, the prosecution's theory would criminalize advocates for criminal justice reform who met with members of Congress and presented supposedly false statistics about the impact of incarceration on minority communities to advocate for the passage of criminal justice reform bill. So long as prosecutors could allege the advocates had a reason to know the statistics were incorrect, or were supposedly notified of that by government officials, these advocates could be charged with conspiracy to defraud the United States. I do like this parade of horribles. It's actually pretty good. Like, here's some other things that it would sweep in by their own logic. Yeah, this works. This works. Anyone who lobbies federal officials to act based on vigorously disputed, not readily verifiable facts would face the pall of prosecution and imprisonment for up to 20 years under this theory. Yeah. Applied as the prosecution suggests, the statute would criminalize an enormous amount of ordinary, routine political activity by millions of American citizens, exalting the government's assessment of facts over our most sacred right to state our political opinions and then making them known to our elected leadership. For this reason, in McDonnell, the Supreme Court unanimously rejected a similarly expansive interpretation of the statute that threatened to criminalize broad swaths of ordinary political interactions, including even the most basic commonplace requests for assistance from citizens to public officials. As in McDonnell, so as here, the government's position could cast a pall, a potential prosecution over these relationships, as someone lobbying the government over a hotly disputed issue might wonder if they'd be prosecuted for taking in a supposedly false position on a disputed political question, and thus citizens with legitimate concerns might shrink from participating in democratic discourse. In short, the law does not prescribe advocacy on political issues in the manner described in the indictment, as such actions are neither deceit nor trickery, and cannot be considered as such without improperly criminalizing vast swaths of the citizenry. Therefore, the indictment does not state an offense and should be dismissed. Okay. All right. I think that makes a lot of sense. I find that pretty good persuasion. All right. Yeah, that's pretty good. The indictment's allegations of supposedly false statements about the scope of the vice president's legal authority under the Constitution. Yeah, Wolf Rebel says, while better written than other Trump lawyer briefs, I don't think it's going to fly. It might not fly. You might be right, but I appreciate the effort. Right? You gotta do your best, and they did a good job. So whether or not it ultimately works, they're trying, and I appreciate it. It's well written, and it could always be more successful in appeal. You never know, assuming he's convicted, of course. The indictment's allegations of supposedly false statements about the scope of the vice president's legal authority under the Constitution suffer from the same problems as the statements about the election's outcome. It is well settled as a general rule that fraud cannot be predicated upon misrepresentations of law or misrepresentations as to matters of law. Statements of domestic law are normally regarded as expressions of opinion, which are generally not actionable as fraud, even if false. Yep, that works for me. These are disputed legal claims relating to a widely disputed political issue. Whatever one thinks of the scope of the vice president's authority, to advocate for a broad view of that authority does not constitute trickery or deceit. In fact, it wasn't until the 2022 Congress that, for the first time in our history, sought to limit the vice president's duty in presiding over the electoral vote counting, as they amended the Electoral Vote Act. Next, the indictment alleges that President Trump was involved in organizing and submitting contingent slates of electors from disputed states to the President of the Senate and the Archivist of the United States. But the indictment does not allege any trickery or deceit in the submission of these alternative slates. On the contrary, the indictment plainly and repeatedly alleges that at least 3 places submission of these electors did not involve any trickery or deceit. First, the indictment alleges that there was a clear difference in form between state-certified electors and the alternate slate of electors, and this difference appeared on the face of certificates submitted for rival slates of electors, making these readily distinguishable to federal officials. Unlike those of fraudulent electors consistent with the Electoral Count Act, the legitimate elector-signed certificates were annexed to state executive certificates of assertion before being sent to the President of the Senate. New York Renal Mead said a super chat and I got deleted. I hope that's not true. If that's true, I'm sorry that your super chat got deleted, and that sucks. We like that you're here. Next, the indictment alleges that when unnamed agent of defendant attempted to deliver alternate slates of electors to the vice president through a U.S. Senate office, both President Trump's agent and the senator staff made clear that what were being submitted were alternative slate of electors, leading to the vice president's staff refused to accept them. Apparently, according to the indictment, I guess, on the morning of January 6th, an agent of the defendant contacted the United States senator to ask him to hand deliver the documents to the vice president. The agent then facilitated the receipt by the senator staff of the fraudulent certificates signed by the defendant's fraudulent electors in Michigan and Wisconsin, which were believed not to have been delivered to the vice president or archivist by mail. With one of the senator staffers contacted the vice president by text message to arrange delivery of what the senator staffer had been told were alternate slates of electors from Michigan and Wisconsin. Because the archivist didn't receive them, the vice president's staff rejected them. So no fraud, because they were clear about what it was. Third, the indictment quotes from internal communications involving the internal electors that made clear that according to the plan, federal officials would be fully aware that there would be alternate slate of electors, not electors certified by relevant officials from the disputed states. Okay. The indictment alleges that a prospective elector stated, his idea was basically that all of us, Georgia, Wisconsin, Arizona, Pennsylvania, have our electors send in their votes, even though the votes aren't legal under federal law because they're not signed by the governor, so that members of Congress can fight about whether they should be counted on January 6th. They could potentially argue they're not bound by federal law because they're Congress and they make the law, etc. Kind of wild, creative, I'm happy to discuss. My comment to him was, I guess there's no harm in it, legally at least. That is, we could just be sending in fake electoral votes to Pence so that someone in Congress can make an objection when they start counting votes, and then argue the fake votes should be counted. That quote isn't particularly helpful for them. I think I would have left that one out, but okay. Thus, its alternate slate of electors were submitted on the understanding that members of Congress would fully understand their alternate electors and would debate whether or not the alternate electors should be certified. The prosecution may think this approach was based on baseless legal theory, which is not the basis of fraud. But the indictment does not allege any trickery or deceit in submission of the electors to the officials. Okay, that's pretty interesting. Pretty good stuff. Thank you, Rachel. I appreciate that you're enjoying this, and I appreciate helping to give you good content. Thus, there's no question that every relevant public official identified in the indictment fully understood which slate of electors the relevant states had certified, and no allegations in the indictment suggest that President Trump attempted to cast any doubt whatsoever on the issue. Rather, the indictment alleges that President Trump attempted to persuade officials to consider alternate slates, notwithstanding any earlier certification. They did not involve deceit or trickery as to the electors in and of themselves, but rather protected speech regarding the conduct of the election itself. Given this, it's clearly no accident the indictment fails to allege trickery or deceit in the submission of the alternate slate of electors. Okay. It could not plausibly do so because the plan to submit alternate slate of electors was openly discussed by those involved and widely reported at the time. The Washington Post reported that those involved in organizing pro-Trump slates of electors in disputed states boasted publicly about the plan. In the weeks before January 6, Trump supporters boasted publicly that they'd submitted so-called fake electors on behalf, but the Justice Department declined to investigate the matter in February 2021. Indeed, the alternate elector plan was broadcast on nationwide media, touted on Fox News by President Trump's senior advisor, and subject to contemporaneous op-eds in the Washington Times. They weren't trying to keep it a secret. They weren't trying to fool anyone. They weren't trying to trick anybody. So, yeah. Thank you, DFell, for following me on Twitch. Thank you to MD Asker Rahman for following me on Facebook. Next, the indictment alleges that one or more of the fraudulent electors have been induced to participate in the plan through alleged false premises made to another, not to the defendant. When the defendant's electors express concern about signing certificates representing themselves as legitimate electors, co-conspirator 1 falsely assured them the certificates will be used only if the defendant succeed in litigation. But even if this allegation were true, which it's not, and even if it somehow involved trickery or deceit, it does not constitute defrauding the United States. These allegations do not identify any supportedly deceitful statements made to a federal official, only to other participants in the alleged scheme. All right, that's good stuff. I like that. That's nice. As the Supreme Court held in Tanner v. United States, the conspiracies criminalized by the law are defined not only in the nature of the injury intended by the conspiracy and the method used to effectuate the conspiracy, but also, and most importantly, the target of the conspiracy. Thus, an alleged fraudulent misrepresentation directed and designed to induce reliance by a private third party does not constitute fraud against the United States. That's true enough as it is, yeah. As far as it goes, that's appreciated. Okay. In fact, an interpretation that would criminalize defrauding a private third party under the law has not even an arguable basis in the plain language. I see you on Twitch. Thank you very much. Unless the conspiracy intends that a third party will relay the alleged misrepresentation to federal officials, or the third parties acting to the federal government, neither of which is alleged to no attempt to defraud the United States is at stake. For similar reasons, the indictment fails to allege any conduct that constitutes obstructing or interfering with a governmental function. Political advocacy to public officials, even if the one lobbying them makes claims on widely disputed issues that federal officials deem to be false, does not constitute obstruction or interference within the meaning of the law. For cases that go beyond the heartland of common law fraud, the Supreme Court has adopted a narrowing construction of the statute that requires a showing of an attempt to obstruct or interfere with a lawful government function. To conspire to defraud the United States means primarily to cheat the government out of property or money, but also means to interfere with or obstruct one of the lawful government functions by deceit, craft, or trickery. The Supreme Court has stated repeatedly that fraud covered by the statute reaches any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department or government. Thus, a defraud clause conspiracy requires 4 elements. Defendants entered into an agreement to obstruct a lawful function of the government or an agency of the government by deceit or dishonorable means, and at least one overt act in that conspiracy. To obstruct means to place an obstacle in, or fill with obstacles impediment, or hinder from passing actions. Impede. One does not obstruct congressional operations by lobbying members of Congress to act in certain ways. On the contrary, such political advocacy is inherent in the system. True enough, that's true as far as it goes, yeah. The basic compact underlying representative government assumes public officials will hear from their constituents and act properly on the concerns. The government's position could cast a pall of potential prosecutions over these relationships. Yeah, that's true. And a constituent does not obstruct governmental functions by asserting views on a widely reported controversial topic that the prosecution does not share and think is false. Trump was just fined $10,000. Yeah. One such widely disputed topics, members of Congress and other government officials have full resources and opportunity in the form of their own opinions and draw their own conclusions. Okay. Yeah, that makes sense. I like his statutory construction. It makes sense. Yeah, it makes sense. There's some good stuff there. Several principles of statutory interpretation all support the same conclusion, that the conduct alleged in the indictment does not fall within the statute as a matter of law. First, courts routinely observe that the law is an extremely broad statute, and they interpret it narrowly in individual cases to offset potential overbreadth. Unlike mail and wire fraud statutes, which have been interpreted to incorporate elements of common law fraud, this law has been interpreted to criminalize any willful impairment of legitimate governmental functions, whether or not the improper acts or objective are criminal themselves. Okay. Precisely because it's so broad to the point of raising serious vagueness concerns, courts adopt narrower and more cautious interpretations of the law to foreclose novel applications of the statute, especially when those applications risk criminalizing ordinary conduct or political advocacy. As the Ninth Circuit holds, recognizing the broad scope of the law, we review indictments under it carefully and construe it narrowly. The Supreme Court has likewise emphasized that indictments under the broad language of the general conspiracy statute must be scrutinized carefully as to each charged defendant, because the possibility that its wide net may ensnare the innocent as well as the culpable. That caution applies here, where the prosecution advances an interpretation that would cast a wide net of the law to ensnare large numbers of people engaging in perfectly ordinary conduct. Good stuff. Second, the court must construe the law narrowly to avoid grave constitutional questions that criminalizing the charged conduct would raise. As discussed in the alternate memorandum, which we read earlier, all the alleged conduct constitutes First Amendment protected speech, advocacy, and association, and the application of the statute in this context violates the fair notice requirement of the due process clause. Accordingly, applying the statute to this conduct would, at the very least, raise grave constitutional concerns. When an otherwise acceptable construction of a statute would raise serious constitutional problems, the court will construe the statute to avoid the problem unless the construction is plainly contrary. This is standard. We do try to interpret the statutes in a way to avoid constitutional problems, not create them. I hope you don't feel that way, Lillian. We try to make things pleasant here in the chat. The moderators will help make things pleasant. The elementary rules that every reasonable construction must be resorted to in order to save a statute from unconstitutionality. Yeah. This approach not only reflects a prudential concern that constitutional issues not needlessly be confronted, but also recognize Congress, like this court, is bound by and swears an oath to uphold the Constitution. The courts will therefore not likely assume that Congress intended to infringe constitutional liberties. Yep. Here for the reasons discussed above, the interpretation of law that does not criminalize President Trump's alleged conduct, and by extension the conduct of millions and millions of citizens, is at least plausible. By contrast, the prosecution's alternative interpretation would raise grave concerns. In fact, it would criminalize conduct directly protected by the First Amendment. Likewise, the narrower interpretation of the statute is necessary to avoid fatal vagueness problems. If, as the prosecution contends, any statement made in the course of advocating one's position to federal officials on a hotly disputed political topic may constitute conspiracy to defraud the United States, so long as the prosecution later deems them false, the statute fails to satisfy basic precepts of due process. This interpretation, if adopted, would render the statute unconstitutionally vague because it would not provide fair notice of the conduct prohibited and would lend itself to arbitrary and discriminatory enforcement as presented here. More soundboard. I only use the soundboard when appropriate. I just don't, I don't have soundboard for everything, but to satisfy due process, a statute must define a criminal offense with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. The void for vagueness doctrine embraces these requirements, and interpretation that leaves the statute's outer bounds ambiguous and effectively grants prosecutions wide discretion to determine what conduct is criminal is unconstitutionally vague. As discussed more detail herein, if interpreted to cover these charges, it violates due process. Maybe. It's well established that ambiguity concerning the ambit of criminal statute should be resolved in favor of lenity. The Supreme Court has repeatedly applied this rule of lenity to prevent overbroad application of federal fraud statutes. The rule of lenity provides that when two interpretations of a criminal statute are available, the court must adopt the one that favors the criminal defendant. Likewise, the principle of restraint in interpreting the criminal statute calls for an adoption of a less harsh alternative. Thus, the Supreme Court has stressed repeatedly that when a choice is made between two readings of what Congress has made a crime, it's appropriate, before we choose the harsh alternative, to require that Congress should have spoken in language that's clear and definite. In a case called Cleveland, the Supreme Court held that a federal mail fraud statute couldn't be applied to a scheme to procure a state poker license through false statements to a state agency. In applying the rule of lenity, the court emphasized the rule prevents an interpretation that would arm federal prosecutors with power to police false statements in an enormous range of submissions to state and local authority. The same reasoning applies here. All right. That all makes sense to me. Lemon Fresh, this is the motion to dismiss filed by President Trump in the DC case currently pending against him. This is the second motion to dismiss, the one on statutory grounds that we're reading right now. And it's written pretty well. Excuse me. The wholly false premise of the indictment is that President Trump made allegedly false statements to congressional officials, including Vice President Pence in his capacity as President of the Senate, to induce official action that would alter or delay congressional certification. Yet conspicuously absent from the indictment is any charge under the federal false statement statute. Interesting. That's an interesting point. The reason why becomes clear when examining the plain text of the statute, which expressly excludes any purportedly false statement reporting regarding any matter within the jurisdiction of the legislative branch, except two non-applicable exceptions for administrative matters or any investigation or review conducted pursuant to authority of a committee, subcommittee, or other House of Congress. The purpose of this broad exclusion is plain. Although Congress may have a specific need to regulate statements made, typically under oath to its committees, broadly prescribing all allegedly false statements made to legislatures would potentially criminalize vast swaths of speech and conflict with the First Amendment's guarantee that citizens may petition our leaders for redress. That guarantee that also always applies, no matter how much our leaders or other government officials disagree with such grievances or believe are baseless. It is a fundamental canon of statutory construction that the words of the statute must be read in their context and with a view to their place in the overall statutory scheme. A court must therefore interpret the statute as symmetrical and coherent regulatory scheme and fit, if possible, all parts into a harmonious whole. Yeah, that's what you always try to do, right? You always try to read statutes and particularly parts of statutes, but even statutes between statutes, you try to read them as part of a coherent thought, right? The law should be coherent. That's what that says. That's good stuff. Similarly, the meaning of one statute may be affected by other acts, particularly where Congress has spoken subsequently, and more specifically, the topic at hand. That's possible. Here, the prosecution asks the court to ignore Section 1001's place in the regulatory scheme and conclude that, notwithstanding congressional direct exclusion of legislatively directed statements, strained interpretations of other statutes, none of which have any direct application, may nonetheless criminalize the same alleged conduct. The court should reject the argument. Congress, for good reason, chose to limit the section's reach. Other more general statutes, including a different section and all that is charged, must be interpreted with this limitation in mind, foreclosing any construction sufficient to support the charge. Again, I mean, I don't know if they're necessarily going to win, but they're setting up themselves the argument. They're doing a very good job at it. And assuming President Trump is convicted here, an appeal court might readily agree. Probably not the DC Court of Appeals, but you never know what the Supreme Court might do. And of course, this being federal, the Supreme Court getting involved is a very distinct possibility. Matthew Felty gave $1.99. Jason J says, I have a question. Can a motion to be dismissed be partially granted? Yes, absolutely. A motion to dismiss can be granted in part. Okay. Count 2 of the indictment alleges conspiracy to obstruct an official proceeding. Count 3 of the indictment alleges obstruction and attempted obstruction of official proceeding. The law was enacted as part of Sarbanes-Oxley in response to the Enron scandal to close a loophole in federal criminal law on evidence tampering. Congress enacted the law as part of the Sarbanes-Oxley Act, which was prompted by the exposure of Enron's massive accounting fraud and revelations from a company outside auditor that had systematically destroyed potentially incriminating documents. The Enron prosecutions revealed a critical gap in the U.S. Code. The then current version of the law prohibited a defendant from persuading another person to destroy records in connection with an investigation or other proceeding, but imposed no liability on those who personally destroy the evidence. Thus, the indictment takes a statute directed at destruction of records and accounting fraud and applies it to disputing the outcome of the presidential election. This stretches the statutory language between any plausible mooring to its text, which violates statutes of avoidance, leniency, and restraint discussed above. Excuse me. The section of the law provides that whoever corruptly obstructs, influences, or impedes an official proceeding or attempts to do so commits a felony. The law provides that whoever conspires to commit any offense under the section shall be subject to the same penalty as those for the offense, which was the object of the conspiracy. Counts 2 and 3 fail as a matter of law because the indictment does not properly allege that President Trump acted corruptly or that his conduct attempted to, conspired to, or did obstruct or impede the election. First, the indictment does not allege any conduct that could constitute obstructing or impeding an official proceeding. As noted above, to obstruct means to place an obstacle in, or fill with obstacles or impediments, or hide from passing, action, or operation. Impede. To impede means virtually the same thing as to obstruct. To interfere with or get in the way of, to hold up or block. The definition of obstructs makes clear the virtually identifiable meaning by defining obstructs in terms of impede. As discussed above, lobbying members of Congress and state officials to act in a certain way when they conduct official proceedings does not obstruct or impede that official proceeding. Nothing about lobbying Congress to act in a certain way places an obstacle or impediment, hinders action, gets in the way of, or upholds or blocks Congress from acting. On the contrary, lobbying Congress to act in a certain way presupposes that Congress will conduct an official proceeding and seeks to persuade Congress to act in a certain way during that proceeding. That is the antithesis of obstructing. Oh, yeah, that makes true, yeah. All right, I think we'll get to the end of the section and call it a day because I'm losing my sales. But we got through one whole document, and we're going to make it at least to the end of this one, I think. The canons of interpretation that apply equally here. The canon of constitutional avoidance instructs the statute should be interpreted to avoid criminalizing First Amendment protection activity. The narrow interpretation avoids the potentially fatal vagueness and fair notice problems. The rule of lenity and restraint counsel in favor of narrow interpretation as well. By contrast, the prosecution's alternative interpretation, that someone who lobbies Congress to act based on views and opinions the prosecution disfavors as somehow obstructing and impeding Congress, is novel and unprecedented, and again threatens to criminalize broad swaths of activity. On the prosecution's view, an activist who lobbies Congress to oppose COVID mandates on the ground the vaccines do not present the spread of COVID would be obstructing Congress. Sandy gifts 10 gift memberships. Thank you very much, Sandy, for your continued support of the channel. And I think we will end there because we've reached the end of that section and I am tired. Yeah, because the next section goes on, for like 5 more pages. I think we need to end it here because I've been reading for a while. And but I think that's pretty good stuff, right? I think some of these arguments make quite a lot of sense on the statutory grounds. And some of these arguments on the constitutional grounds, I think also are at least applicable, although not completely, but some of it is applicable to the Georgia case, because I think you can make a very credible argument that a lot of what Trump is being prosecuted for is his speech, and that this conspiracy idea is really kind of neither here nor there. So I think some of this may be very well applicable to the Georgia case. And now the problem there statutorily is that Georgia's RICO is so broadly written, as I'm getting into in my video tomorrow about the subject. But Georgia's version of the RICO is so broadly written, I don't think you can make the same statutory arguments, but I think you can make some of the same or at least parallel constitutional arguments in the case. So I think there's some possibilities there for sure. So that is, but the Georgia RICO case, I think, is the most interesting one legally, because Georgia's RICO is so broad, and the political aspect of it, I think, is more apparent, or the most apparent, in the Georgia RICO case of the cases that are pending. Like the politicalization of it, and how Fani Willis is using this for political ends, at least in part, and how, there's political aspects to it. There's a lot more there, I think, in the Georgia case than the other cases. So we'll get into that probably more tomorrow. But this is pretty good stuff. So, do I think I'll get into the Illinois firearms license Supreme Court case? Probably not. State law. Probably not. I don't know what they'll do, and not really, not unless I see a lot of interest for it. Probably not. But I think that will sign. Trump was fined $10,000. Yeah, I saw that. Yeah, it is what it is. It's a thing. And the House finally has a speaker. How exciting. Mike Johnson is now the speaker. That's exciting. Well, Mike Johnson was not the name I thought would take the day, but I guess I didn't know that one. So, all right, Mike Johnson is now your speaker. How exciting. Fun, exciting. Until someone decides no confidence in him, if he didn't amend the rule to allow that, he's an idiot. Like, surely they amended the rule, right, to just allow a no confidence vote by, like, unless the caucus is a majority votes. Yeah. Was there not a speaker? There has not been a speaker for 3 weeks. No. It's been a thing. Yeah. All right, I'm going to sign off for now. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.